what we call shotgun legislation. Well, Malaysia was one of those, what I call a premature gestation. And you also had countries who were a bit more cautious, who had the approach with caution approach. So UK is one example, which decided to have a discussion about it, had a parliamentary select committee about it. In Australia, for instance, this year they've had a public national inquiry on this issue. There is also some work at the ASEAN level, and this was a framework that was signed in May of last year in Singapore, and what it covers, apart from laws, is a wide number of initiatives that you can take up as opposed to just legislative initiatives. For example, of course, education and awareness of the public, detection and response. So here in Malaysia, we have the Multimedia Commission who can do that. Community and ground out participation. So for example, in schools, getting it into our education curriculum, getting communities to talk about this phenomenon. And of course, norms and guidelines, and this is where laws come in. So and interestingly, it was the last suggested initiative on this framework that you should really try to attempt other initiatives, but then since states are sovereign and autonomous, they can, if they wish to, pass these laws. But what I will not cover in my lecture today, because the lecture is on legal perimeters, I am not going to talk about non-legal perimeters, but I am going to mention them to you in passing. So for example, why do we rely on fake news? That's because we have skepticism with mainstream media. So one of the non-legal parameters to be undertaken, one of the non-legal initiatives to be undertaken is to promote and invest money in high quality news and journalism. And this is something that's helped in Malaysia. For example, after May 9 last year, there seems to be a lot more trust, a lot more reading of mainstream media than there was before that. But this has also got to do with a bit more openness in the way journalists were reporting things without fear or favor. Okay, so that can be some consequences or ramifications, or should I say positive changes as a result of the elections. But what is also interesting is there are initiatives in other countries, or should I say within regional organizations like the European Union. So they've come up with a code of conduct which is voluntary, and you've got Facebook, you've got Google, you've got Twitter, Mozilla that have signed up on this code of conduct. But of course, this is limited to the European Union. And of course, the rest of the world will have to fall back on the various community guidelines that these social media platforms are utilizing. But there you are. You do find some initiatives at a uniform to create some sort of uniformity in terms of regulating messaging services. I will not be talking about things like architectural restrictions. I'm not sure if you realize that you can only forward your WhatsApp message now to 5 people. You can only have up to 50 people on a group in WhatsApp. Now this is as a result of how WhatsApp was used in India. So a lot of riots and a lot of concerns. Of course, every country is impacted differently by fake news or online falsehoods. So in Malaysia, it could be racial and religious disinformation. In Singapore, it could be political disinformation. In India, it is a whole host of things. Okay, and an hour of this lecture, and yet I will not be able to cover what is happening in a socialist democracy like India. So I will not be talking about architectural restrictions. Now this is a very quick globe that one of my fellow panelists who are going to be on this panel in Seoul shared with me. This is not new information, it's been around, and it's from Pointer. So what this atlas shows you is pretty much what is happening around the world. And of course, there are parts of the world where they've decided to set up task force and take what we call a softly approach to fake news. But in countries like Germany, in France, of course, in Singapore, recently there has come out with a very comprehensive legislation. I'll talk about it. And really, there's nothing to criticize about the legislation after reviewing it. I think it's a very sophisticated legislation. This is not something that you may want to hear, but I will tell you at the very end, I'm quite a sympathizer towards regulating fake news. So just a bit of a background in context of Malaysia. If you just look at the timelines, you will see the speed in which the legislation was passed in Malaysia. So hence my favorite phrase when I refer to the Anti-Fake News Act, a premature gestation. So you can see there was a cabinet approval in March, next thing you know, it's law 9th April. So at the time when the second reading debate was taking place, I remember I was actually, Edmund, at your office doing some MIRA work, and I got a call from the Bahagian Hal Ehwal Undang-Undang that they are inviting me to come and observe the second reading speech. And this was on the morning where this debate was going to take place. So that will just tell you how quick and fast the pace in which the legislation was passed, and you'll be quite critical of the legislation when I show you what it covers, especially when you compare it with how the Singapore legislation has decided to tackle the problem. However, there were attempts to repeal it, but there were impediments on the part of the Senate. So basically here in Malaysia, the Senate can only delay a bill for a year. So we are basically waiting for a few more days for that year to pass, and then the Senate will be bypassed and the repeal bill will be enacted, and we're waiting for that news. So one of the things that I want to mention as a footnote is the perception that the public and the citizenry has towards this legislation. Much of the citizenry prior to the general elections felt that this was a last-ditch effort on the part of the government for some sort of salvation. So with it comes this sort of negative legacy. So if we talk about, for example, today that we need a sophisticated act to cover online falsehoods, it will not be a popular initiative, simply because it is tainted by the legacy of the previous regime. So the idea of the Fake News Act was to silence dissidency to the run-up of the elections. Now, what is very interesting, and again, I want to say at the outset, is when we look at Malaysia and the whole plethora of legislation that exists in Malaysia to silence discourse and socio-political speech, it is still amazing how effective free speech has been in this country. From the time of the first assembly of Bersih to the May elections, many observers have said that much has to do with the amount of free speech that we had, facilitated by social media platforms, starting of course with blogs. So Malaysians found a new place to assemble, the cyberspace, the digital sphere, a new medium to speak through. And of course, a lot of social media platforms did not expect to work and function in that way as a tool of free speech. So some of the things that I actually talk about from my research, or in my research, are some of the challenges and uncertainties. So one of the first things I want to flag up is, before you enact any law in a proper functioning democracy, you have to have proper consultation. This is vital. And this is the hallmarks of a quality legislative process. Second thing is, in a state that has a constitution, you have to measure up any initiatives that you take that attempts to curtail fundamental liberties like free speech. You have to engage with constitutional principles. Thirdly, you have to look at the scope, the breadth, the width, the depth of the legislation. That it must, to a large extent, not be countervailing to our fundamental liberties. So the Constitution is something that we have to fall back on as a yardstick, as a measurement. And these are two things that I'm going to focus on today. We also have to look at the courts, because that's where we've been told justice is administered. So a person has been prosecuted for disseminating online falsehoods. He will be charged in a court. And of course, if the matter goes on appeal, his lawyers are bounden to argue that this legislation is unconstitutional. So it falls back on the courts now to interpret our rights. How do courts interpret our rights? Do they interpret it in a very literalist fashion, how should they do it? And this is one of the things that I'll be talking about quite briefly as well. Now, the elephant in the room, as I always, a phrase that I often use when referring to prosecutorial guidelines. Why is it the elephant in the room? You can have any laws, but you must have thresholds. If you commit a crime, when does it cross the line? When does conduct that is harmless becomes harmful? So if we do not have prosecutorial guidelines, then really it is pretty much lies in the hands of the Attorney General, his constitutional discretion, to charge a particular individual. So there needs to be a threshold. There needs to be some kind of a yardstick. This is again a problem, not just in Malaysia, in Singapore, where many people are more sympathetic towards the Attorney General's office as opposed to having something that's open, transparent, and subject to scrutiny. We also need a consistent approach in prosecution. We cannot have any sort of inconsistency in the way in which we criminalize people. So if we feel that a particular statement has harmful consequences because it's going to cause racial, religious disharmony, which is going to lead to compromising security of a nation, then this standard must be practiced across the board. And this is, of course, something that is part of our conversation in the last few weeks in reference to Zakir Naik, for example. What are the authorities doing in respect to someone who may have said something that is a bit sensitive? Now, the last two, I wish I had time to cover. My biggest concerns, when I first started dabbling in this area of free speech, where I felt that the internet was the greatest invention ever, thanks to Tim Berners-Lee and his HTML language, and created the World Wide Web, led to Web 2.0, and then we had these big tech giants coming and bending around this phrase, free speech, uses as a tool of expression. I think from the time I completed my PhD, which was in 2012, and today, I think my view of these big tech giants has reversed. We were concerned with Big Brother, now we have to be concerned with the big other. Big tech giants are doing a lot more surveillance than the governments are doing. So I have a lot of concerns about relying on social media platforms, having them to be accountable and responsible, to be the gatekeepers of harmful news, in particular online falsehoods. And I think you just have to think about, I just have to mention one word, Facebook and their relationship with Cambridge Analytica. And this is a very good example of things going quite wrong, okay? So unfortunately, I don't have time to really talk about the last two concerns. So I thought I wanted to give an overview of, because we have audience from a wide participatory range across our community here at the university. So I wanted to put into context, this is of course boring stuff for the lawyers in the room, my colleagues, constitutionalist lawyers here who are better experts at this than I am, Mr. Mark Goh, sitting quietly in the corner. And he's promised me he's going to ask some very awkward questions. Please limit those to the presentation, Mr. Goh. So, as most of you would know, we have a constitution. It is the supreme law of the land. It was drawn up by the Reid Commission. There are a lot of things that were said in the Reid Commission report that talks about, in particular, Article 10, which I will mention later, which gives us the right of free speech and expression. And you can tell from the text of the Reid Commission report itself that the intention was for these rights to be prevailing rights. But what has happened recently, I wouldn't say recently, actually from the time of independence, is this so-called prevailing right has been restricted by various acts of parliament, various legislation, which I'll talk about in a bit shortly. But the biggest problem is really the problem of interpretation. The courts have been very regressive, have been very restrictive in the way in which they have been interpreting provisions in the Constitution. And I'll give you the reasons why there is this problem. So this is, of course, the most debated article, I would say, one of the most debated articles. The great bane to our courts, really, is Article 10. And Article 10 says that every citizen has a right to freedom of speech and expression. Now, I want you to note that it's pretty much limited to citizens of the nation. And it doesn't say every person, as does for example, the ICCPR, the Universal Declaration of Human Rights, which refers to every person as opposed to every citizen. Now, what is interesting is how most rights that are accorded to us are qualified. And of course, because nothing should be absolute. There must, for example, even in the US constitutional discussions on the right of the free press and the right to free speech, there is what we call the clear and present danger test that has been developed by the Supreme Court. So we find in Clause 2 some of these restrictions, that whatever we say and how we express ourselves must not be harmful or have harmful consequences. So for example, we can have restrictions which have been imposed by law, so by Parliament. So Parliament can restrict these rights, can restrict our rights, can restrict the exercise of our rights. And in particular, when it's necessary, which is a very important word to hold on to, and it must be expedient in the interest of the security, to maintain public order or morality, and so on and so forth. So to cut a long story short, there is a threshold for Article 10, that we have this right, but this right must be exercised responsibly. But if it leads to harmful consequences, as those articulated by our founding fathers, that these restrictions get in the way of national security and harmony and may lead to disorder, then we can have acts of Parliament that do this. They act as restrictions to our rights. So I will refer to these laws as restricting acts of Parliament. So we're very clear we have these rights, but what is the problem? So there's a lot of restrictions on Article 10. So the first thing I'm going to say, and I might be criticized for using this word, the timidity in the way in which our courts are interpreting our rights. So much so, there is very little progress in the way these rights are enhanced. So I call this that they've been reduced to what we call illusory rights. So if we say we have a right to speech and the right to speak and to express ourselves, but at the very same time, we have a whole host of legislation that restrict us. Even post GE 14, you still have threats of prosecution under the Sedition Act. And of course, the most ominous of them all is the Communications and Multimedia Act. So very recently, the time when of the abdication of the king, 3 people were prosecuted for saying things against the monarch. 2 pleaded guilty, 1 is challenging the prosecution. So how we are using the Communications and Multimedia Act, it is akin to, I think it's the modern version of the Sedition Act, if you really ask me. If the Sedition Act was a colonial legacy, well, we've got a very modern legislation that's doing the same. And what is worse is the prosecutorial arm of the Act, the Communications and Multimedia Commission, the watchdog somewhat may have been a bit too aggressive in the way in which it's prosecuting speech today. So let's go back to these rights, that whilst we have this provision that accords us our rights to speak freely, but these rights are seen as illusory because they have been limited in the way the courts are interpreting it. So what has this led to? It has led to no protection or little protection of important speech. So not every speech is important. There is a scale. And one of the kind of speeches that are at the top of the scale, and uppermost of the scale, is what we call socio-political speech. So speech that is important in conversations among citizens to make the executive accountable, responsible, to ensure that the organs of state are open to scrutiny so that there are checks and balances of powers. Nothing new. In any functioning democracy, these are principles that are important. What is also very concerning is the slow development of media rights in common law principles. So for example, let me explain this. We have media, but we don't give them the rights to act as, for example, the fourth estate. So we've got 3 organs of government. The media is seen as the watchdog for these 3 organs: parliament, legislature, executive, and judiciary. So in Malaysia, we have a lot of laws that restrict the media, but there are no laws that lift the media to this role as a fourth estate. So since Parliament has done us a disservice, we have to rely on the courts to accord our media entities rights. And this is where our courts have not been very good at. They've not been very good at according rights. There have been attempts, and I like to say there is some progress, but more needs to be done. And there is other research areas that I'm doing, for example, things like gagging orders, how do courts look at gagging orders which gag the media. So this is, I suppose, another presentation for another day. So you can see that whilst we have Article 10 in the previous slide, we have what we call a weakness in our structure, our legal structure here. And that goes back to the attitudes of the court. So when we talk about judges, again, which is a discussion for another day, we have creative judges, and then we have what we call, and creative meaning liberal judges, and then we have conservative judges. Now, why do we place these tags on them? It's because of their attitude towards interpretation, which I'll talk about shortly. So, Gopal Sriram is very busy today, in the last few days. Okay, well, Justice Sriram is, of course, one of the most eloquent and most famous judges that we will, probably second to Sultan Azlan Shah, that we will ever have. And he's a great proponent of using a more liberal method of interpreting constitutional rights. And what is this? This is called the ambulatory, or what we call the prismatic approach. Now, this is not new. These debates, firstly, are not unique to Malaysia. So even though we have a lot of judicial liberalism in the way in which constitutions are interpreted, say in the US, even in the US itself, these debates are taking place, because there is a school of, say, literalism, okay, that you can literally interpret the Constitution. Now, Gopal Sriram disagrees. He said you cannot look at Constitution in the same way as you look at legislation. So he says you have to shift from literalism to what he calls a broad construction. So he talks about the prismatic approach. And why ambulatory? Ambulatory meaning that when we are interpreting something, it's not fixed, that this interpretation should be what we call a living and an organic interpretation. So literally what it means is, so if I've just used the image of a prism. So for example, in Malaysia, I want to move away a little bit from free speech. Let's say we have the right to personal liberty, for example. So what do we mean by liberty? It's one word, but liberty can mean a number of things. So my other area of specialization is information and communication technology law. And there, although in Malaysia we don't have the right to privacy as a right, but we feel that if you use the prismatic approach, that right to liberty can include a number of rights, one of which is privacy. So for example, if you take Article 10, the right to free speech and expression, if we put it through the prism, it can mean a number of things. It can mean, which is something that I'm writing and researching on, the right to protest, the right to go out on the street and to express yourself, the right to assemble, can be part of right of free speech and expression. So this prismatic approach is what Gopal Sri Ram talks about. And again, this is not in any way inventing a wheel. It is simply extrapolating legal pronouncements that have been made by judges in other jurisdictions. And in his paper, The Dynamics of Constitutional Interpretation, he refers to English authorities. And basically, these English authorities are really suggesting that we need to shift from a literalism and a narrow construction to a wider construction, what we call a prismatic construction. So again, a bit of a footnote so that you don't trash our judges. These debates do not just exist in Malaysia, but in most constitutional legal systems that have a constitutional tradition. So my last point on the interpretation of Article 10, again, not forgetting why we are here today, we are discussing online falsehoods. Why are we discussing Article 10 vis-a-vis online falsehoods? That if at all we are going to have any law on online falsehoods, we must make sure that that law must be weighed up so that it is reasonable and it is proportionate. So some of the tests that our apex courts, our appellate courts, as well as our federal court has expounded on are some of these tests. So there's a great tradition that we can look within. We don't have to look without. We look within our jurisprudence. There are these tests. But what is going wrong? If we have these tests that are so well established that should we have a legislation passed by an act of parliament, we can measure this legislation against Article 10 using this test and saying, maybe you've crossed the line with this law. Maybe it is excessive. Maybe it has trampled Article 10. Maybe it is too restrictive. But where is the problem? The problem is the courts who are applying this test. So there are many stages in which I wrote a paper, which is 15,000 words, which just celebrated 1 year on the editor's desk. I wrote it last year, so I just celebrated a 12-month anniversary this month. Okay, a 15,000 word essay where I go through these tests and how these tests have been applied in our courts. And there are many stages. There's what I call the flatline or regressive stage. Now this is where the courts don't want to move. They are taking a very literalist approach to interpreting Article 10. And then we have what we call the oscillation stage. So we have Justice Sri Ram, who's promoting while he's in the Court of Appeal, and then later in the federal court, the prismatic approach. And then you have the rest who are yet to be converted. So you see this oscillation. You see the schisms between judges, whether they want to take a literalist approach or a more liberal prismatic approach. So I've left it with a question mark because it's been 12 months. I refuse to go back to that article and see what else has happened since last September, whether there's been progress or not. So I'll need to do some updating, whether since the change of the government, since there is a new Chief Justice who on her first day said the judiciary is accountable to the public, maybe things have shifted. So we need to give it some time before we can go back, do a bit more empirical studies into the judgments, and then decide whether we have had progress or not. And that takes us to what we call the threshold of harm test. So this is the second thing that I want to talk about. Now, I'm very excited about this because I got to meet the Deputy Public Prosecutor at that time, who is one of the leading golden boys of the Labour Party, Keir Starmer. And at a time when he was the Deputy Public Prosecutor, and he had come out with these guidelines. He has a real keen interest in prosecutorial guidelines. Why? Because he's a barrister, and of course, he's a socialist. He feels that there must be some kind of openness and transparency in the way in which prosecutorial actions are taken. So, through the Crown Prosecution Service, the only guidelines that my research and my research student came across any sort of guidelines, and the only ones that exist that deal with communications on the internet, and in particular, in this case, social media platforms, the only one that I can come across, if I stand corrected, to my knowledge, if you come across any, email me please, I'll buy you a cake and coffee. This is the only one we came across. But what we did come across, and I'll tell you very quickly now, what we did come across, some attempts to ask prosecutors whether they have any guidelines. And the most recent was Singapore. So when Singapore passed recently its legislation, which we're going to talk about very shortly, one of the questions asked was, are there any guidelines to prosecution? And what they did is they referred back to the Constitution. They said, Attorney General has the absolute power to decide to institute proceedings in court. That was their response. So it's more protecting the office of the Attorney General, because in a paper, they said that, in a response, they said that it will subject a high degree of scrutiny on the prosecution, on the prosecutor's office, which is, I find, very bizarre, because the prosecutor's office, the AG's office, is a public body. He's a public person within the legal system. And how can it not be open to scrutiny and accountability? So there's a lot to be said about these guidelines. And like I say, in our review of Commonwealth countries, in our review of any Westminster models, because we have to understand that we cannot compare with nation states that have a totally different model of legal system. So it must be apple and apple, not apple and orange. So we didn't come across any except these. These are the only ones. This is the only one, sorry. So one of the things that these guidelines talk about is, the first thing they talk about is this balancing act. So in the UK, the Human Rights Act is still part of the law in the UK. Theresa May was pretty unsuccessful. She was very busy with Brexit. She didn't have a chance to repeal it. So the European Convention of Human Rights guarantees free speech and expression. So the first thing the guidelines talk about is again a balancing act that we need to do. So any prosecution that is going to be undertaken by the Crown Prosecution Service must not infringe Article 10, which is the right to free speech. Then there is an evidential stage test, meaning if you're going to charge someone for a communication offense, you have to be very clear that you have sufficient evidence to charge. Secondly, there is the public interest stage. That means, is it in the public interest to charge and prosecute this communication? And this is where the guidelines set out, not an exhaustive list, but they set out aspects that must be taken into consideration. But what they do not define, because it is, I think, beyond definition, is what is public interest. So someone comes up with the definition of public interest, please email me. There is no definition that is exhaustive, complete. You'll find it in innumerable occasions mentioned in court decisions, but it is left undefined. So what is in the public's interest would be, to prosecute would be, what are the harmful consequences of that communication? Okay, so if I said I'm going to blow up a building because I'm frustrated, what is the harmful consequences of saying that? Okay, so there's this guy called Paul Chambers. He was waiting for a flight in Robin Hood Airport in Nottingham. He got so fed up and he put on his Twitter account, he said, if my flights are delayed, I'm going to blow up Robin Hood Airport. And he only had a limited number of people who were reading his Twitter feed, but accidentally, two people from, that were responsible, they were in the airport authorities, and they picked up his tweet, and he was charged. Believe you me, this is in the UK, and he went on appeal where the court felt that he should not have been charged. It was a bit too silly to charge him, because everyone knew that he was saying this in jest, that he was just fed up. So one of the things that we have to consider when we are prosecuting is what are the harmful consequences of saying this. For example, look at remorse. A lot of people put things up, and then what do? They remove them. Or they put up an apology. So we have to look at how much of the taxpayers' money we are using to prosecute these people. All right, are we wasting the court's time, which is already suffering from a backlog? If we charge, is it in the public interest to charge this person? Because maybe what he or she was saying was effective communication, was socio-political discourse. Maybe it was a conversation we needed to have. It was a conversation we needed to hear. So prosecutors can get it wrong, as we all know, and our life experience has taught us. Okay, you find people on death row, and then later they are being held to be innocent because the way in which the case was investigated, the way the case was tried, there can be errors in the administration of justice. So what this test creates, what these guidelines create, is really a lesson for us to develop a set of principles or a set of guidelines that will act as what we call harm threshold tests. And we don't have that. So this is really the elephant in the room. So this is the Singapore position. So when there were calls for publishing prosecutorial guidelines, these calls were rejected. And they referred these calls, the people who made these calls, particularly the media players, they said, oh, go back to the Constitution. The Attorney General has this discretion, this power, without answering the question really. And in Malaysia, we have the same problem. There seems to be a protectionist attitude towards a publicly accountable legal personality like the Attorney General. So we have to call to question, why are people being prosecuted under these various legislation? What is the threshold for prosecution? Now, what I say in my research is I make a case to prosecutorial guidelines. I feel that prosecutors should be subject to scrutiny and accountability. They do act on behalf of the public. Because if you go back to the philosophy and the essence and the theory of criminal law, why is it a crime? Because it offends the public. So prosecutors must stand up to this test of scrutiny and accountability. There must be a threshold setting. We have to draw a line where something is harmful and harmless. When is it satirical? When is it just said in jest? When is it just a joke? When is it just frustration? As to something that is more ominous, nefarious, and harmful. And of course, we have a constitution. We cannot just enact legislation and prosecute and criminalize the public without considering the supreme principles of our constitution. Yes, it is a living, breathing document. It is there, it has meaning, it is supposed to be meaningful and not meaningless. So in any way, if we are going to restrict the right given to us by the Constitution, it must be done responsibly. And this is where I make a case for prosecutorial guidelines. And this is the fun part now. Okay, and I'm joking when I say fun because it's really the boring part. It's when we look at legislation. Now, probably a lot of you may be thinking, why am I referring to a Malaysian legislation that is about to be repealed in a matter of days? Because it's a good lesson. It gives us a lesson of what not to do. And many of you may think that our fellow brothers across a small body of water in the south, in Singapore, are less promoting of rights of free speech. Well, all I can say is they have taken a better approach in regulating online falsehoods than most models that I have come across. So just to give you an idea, okay, so we've got our act here that was passed last year. It only has 14 sections and only has 3 offenses, but that's okay. So do the Singaporeans. They have 3 offenses, but they have 62 sections. So just observing why the difference, because there's more explanation, there's more layers of defenses, powers given to the minister, and so on and so forth. Look at the terminologies used. So we've used fake news, they've used online falsehoods and manipulation. So one of the most interesting things was how Singapore initiated this. It wasn't bulldozing a legislation through Parliament. It was taking time to consult, and they had a public consultation. So within Parliament, a select committee was established, and what was discussed and what was tabled before the select committee by interested actors, for example, people from civil society, NGOs, the media, lawyers, they all had a chance to present their thoughts on regulating online falsehoods. So this committee was set up. It's called the Select Committee on Deliberate Online Falsehoods, Causes, Consequences, and Countermeasures. So that's the one up that they had on us. They had a proper, prolonged consultation and a more detailed legislation. So there weren't any ambiguity, there weren't any what we call gray areas, okay? Now, again, juxtapositioning how seriously we took our legislative exercise and how seriously they took theirs. Let's look at the preamble. This is a one-liner from Malaysia, and this is their preamble. And on top of it, with most modern parliamentary draftsmanship, you must always have a section on the objects of the law. And so here in Singapore, our Singaporean brethren decided to dedicate a whole section to explain why. It's a good starting point in most conversations. Why are we doing what we are doing? So you see, the convincing that we need this legislation is more sophisticated. I'm just going to use this word often in this lecture as we come to its close. So there was an extensive preamble, and there was a dedicated section to explain to the public the breadth, scope, width, depth, ambit of the legislation. And it starts always with the question, why? So this just goes to show how serious we were about what we were doing and how serious they were in what they were doing. So let's look at definitions. In Malaysia, we've decided to include news, which simply meant we are no longer just regulating communication between people on social media platforms or messaging services. We have just extended the Fake News Act to mainstream traditional media. And to do that is wrong, because the problem, the phenomenon of all those messages that are being sent to you on your social media platforms, on your WhatsApp, on your Telegram, have a particular nature. It's online. It is digitized. It has nothing to do, the medium has nothing to do with traditional news entities. So this was the big error on the part of our draftsmen and our previous government. Whereas in Singapore, we are talking about a statement. We are talking about a false statement. So what they did is, they said it must be a statement. So meaning it could be a statement within a news article perhaps, but it doesn't criminalize news. So for example, if I'm a journalist and I'm quoting someone who said something, but that turns out to be false and misleading, I will not be criminalized as a journalist. It is the person who's making the statement. I may have just cited it, I may have just quoted it. Okay, so the observation here is that it's too extensive, our legislation. So it extends to just not the online phenomenon, but it extends to traditional mainstream media. Very dangerous. Whereas in the Singapore context, the online falsehood is a statement, a form of communication. And we look at the medium. In Malaysia, it is publication, and it involves mechanically produced publication, which means your printing press. So which means that here, when we are talking about the medium, it extends to online medium and any other medium. Whereas in the Singapore experience, legislative experience, they are saying that it's limited to purely electronic. So for us, it's digital, it's electronic, it's magnetic, it's mechanical. So which will include the printing press. But for them, they limit themselves to the phenomenon being purely online. So they're limiting their ambit and the scope of their legislation. They're not extending it to books, newspapers, and the difference between the use of the word publication and communication. So if you use words like publication, it extends to everything. Whereas in the case of Singapore, it extends to simply what you're saying.
You say the other way around, that publication is more narrow than communication.
In my view, it's wider. Publication is wider.
So if I post something on WhatsApp, I'm not publishing it. Right?
Yeah, that's communicating it. Yeah, so but it's not publication, as in it won't cover, communication will not cover things like books, periodicals, newspapers. Whereas in our case, the definition is so wide, you see, to any written publication. So what they're doing is, you could go back to a book that you've written 20 years ago, and you could still bring it in the context of the Fake News Act. Whereas, because it is still a publication that's being republished, let's say you've got an edition from a few years ago and you republish it, it will still be a publication. And then we have the offenses. And one of the interesting things that is different, I know it's a lot to go through, it's a lot of text, but one of the most interesting things that our legislation didn't cover was the use of bots. Have you been like on a particular website and you have to subscribe or you have to register, and then they ask you to tick this box and say you are not a robot? That's a bot, it's a robot. So you're trying to tell, because you're ticking mechanically, you are telling the website that you're a human being and not a bot. So if you look at how bots work, they're not people. They're programs, they're algorithms, they appear as if they are people. And for example, in today's context of the controversy here in Malaysia about deep fake videos, even Zuckerberg has been a victim of a deep fake video. This is the use of algorithm and artificial intelligence. So one of the limiting aspects of our law is it is not sophisticated enough to cover really the online phenomenon. Well, when we talk about the Russian programmers being so good at creating bots on Facebook and your social media, your websites, this is the biggest problem that we are having. How do we control this? All right, so this is the limiting nature of our legislation, whereas you see the Singaporeans have really taken into account really the problem behind online falsehoods, how these online falsehoods are taking place, and often it is not always people behind these online falsehoods. So it could be a bot that is creating these falsehoods. So you want to implicate the person who is creating this bot, and that's really a challenge. One of the more interesting things are the explicit conditions that have been enumerated. So for example, if you look at all these sections 7, 8, and 9, 7, 8, and should be 9 here, sorry, okay, there is a term, there is a test within the section that you have to prove that communication is likely to do a number of things. So for example, cause harm, to compromise the security of the country. So what they have done is, while they may not have prosecutorial guidelines, but look at what they've done. They have put a threshold in their legislation. So if you permit me, I will just go to very simply just few. One of these, communication is likely to be prejudicial to the security of Singapore or any part of Singapore. So compromises the national security. Prejudicial to public health, public safety, public tranquility, or public finances. Prejudicial to the friendly relations of Singapore with other nations. Influence the outcome of elections. So it's very sensitive. We go back to the Trump elections and the involvement of Russia, for example. And of course, things like Cambridge Analytica. Even here in Malaysia, one of the officials of Cambridge Analytica in an interview openly confessed that they were being used by the previous government. So these conditions are very interesting. So whilst I may be critical of Singapore not having prosecutorial guidelines, what they did is they, in a sense, integrated their threshold in their various sections. So I know I've surpassed the time. So this is the, I have 2 hours. I thought I had 1 hour. Okay, so we can have more time for questions for those who can stay back. I'm very interested to hear your comments and questions. So does Malaysia need a lex specialist? So if we are going to take a step, if we Malaysians are going to take a step to writing up and drafting up a law that is going to deal with this phenomenon, the first thing we are going to ask the Information and Communications Minister and the Prime Minister is not to use the phrase fake news. That will be the starting point, because it is very irresponsible to use that phrase because it doesn't address the real problem. It's not just news and all news that we are concerned with. We are concerned with online communication and online falsehoods. And how we undertake this exercise is very important. So for example, so if you ask me, normally I don't share my personal views, but I have to because this is my research and this is my conclusion, I am sympathetic towards regulating it. Meaning, I think we need laws. I'm going to make a lot of prolific writers and lawyers and academics frustrated, but I sympathize with this phenomenon. You just have to go back to the deepfake video that caused the more recent sex scandal. We have to look at the consequences of fake news post general elections. This phenomenon needs to be regulated. I think it would be irresponsible for the government to say they do not want to regulate this problem, this dilemma. And I'm sure Yang Berhormat Gobind Singh Deo and his team of very prolific lawyers are thinking about this, and policymakers are thinking about this. So I feel the law must be restrictive to online phenomenon. It must not extend to mainstream media. It must ensure clear prosecutorial guidelines to avoid watering down our right in Article 10. There must be clear enumeration of consequences criminalizing the communication, like for example, how our Singapore brethren has undertaken a clear guideline as to what the communication is likely to lead up to, the harm it could lead up to. We need to extend it to bots, deepfake, and AI-generated communication. But what we need before we do all of this is a proper consultation, and we need a proper national inquiry. So, on a personal level, I wanted to end by saying I am sympathetic to online falsehood regulation. I wanted to leave you with a thought and a real story. As you know, in certain countries, people do not have a voice. And so sometimes we have actors who usurp these voices. And many years ago, there was a case of an American man who took on an avatar of a Syrian lesbian blogger to highlight the atrocities that were being faced, that were on a daily basis, faced by the LGBT community in Syria. Is there anything wrong with that? Is there anything wrong with an American man taking on an avatar of a Syrian lesbian blogger? Is there anything wrong with that? This is where I say, to me, the medium is irrelevant. The message really is the uppermost consideration. Thank you very much. So, just a thought. He's a Scottish poet and writer, so you can look him up later. And I'm most keen to take your comments and questions.
Okay, Dr. Jasper, two comments here. The first one is regarding the...
Comments or questions, Mark? Comments or questions?
It's a comment.
Okay, all right.
The first one is regarding the prosecutorial guidelines. You remember you mentioned that Singapore's comment was the AG, you leave it to the AG because the AG has absolute discretion. And you also mentioned that this is the same position Malaysia takes. I believe the prosecutorial guidelines, you can cloak it with constitutional legitimacy. What you can do is to link it to Article 8. So you link 145 to Article 8 because Article 8 generally says that you need to treat people fairly.
Yeah.
And there are cases that say that to treat people fairly and equally is that the discretion that is given to decision makers must be limited. So one of the ways that the discretion of the AG can be limited is to justify it by saying that 145 should be read together with Article 8.
Okay.
Then that will give you a constitutional support for the procedural guidelines.
Yeah. But then that does not answer the question. That's the way in which prosecutorial guidelines are to be carried out and to be used. But it doesn't answer the question, what are these guidelines? So in that sense, there is still this gray area. What are these guidelines? So, but thanks, yeah, I've not considered Article 8, so thank you for that. So whatever guidelines they may have, which is secret, I don't know why, they will have to subject this to Article 8 as an overarching principle. Okay, great. Yeah, thank you.
And the second one is, you mentioned that Malaysia's Fake News Act, right? So we have a fake news, and in comparison to Singapore, and Singapore is a much better act. I believe Malaysia's act it came up like this because it was not thought through.
Yes, absolutely. Yeah.
Okay. The reason I believe behind the Fake News Act was to limit the discussion of the 1MDB. Because they needed to limit the discussion of the 1MDB, the Prime Minister at that point of time had to use different kinds of legislation to cut the discussion because it's going really out of hand. So one of the things that he used was the Fake News Act. So it was, I believe it was passed very quickly, not much thought into it. So they just passed it, they just wanted to clamp down on everything. That's why you got this act. So the present government should actually reconsider and relook at the act and not just simply cut off. I agree with you say that no, it's not right for us not to have a Fake News Act, but then we should actually consider what are the guidelines and what are the sections and what are the contents that should go in.
Yeah, and really deal with the phenomenon, the problem, as opposed to using it as a political tool to silence the citizenry and to have a chilling effect on free speech.
You're right. It was used as a political tool because if you look at the timeline and the way it's passed, it's all to protect the 1MDB.
Yes, and that is why amongst Malaysians we cannot be sympathetic towards such a legislation because of the past behavior of the regime, the Najib regime. So in a sense, if you talk anything about dealing with communication, there's going to be a lot of debate. And so I'm sure, and I'm very confident that the Minister of Communications, the Information Minister, YB Dio, is considering this. I'm very, very sure, because there's been a lot of talk about a Freedom of Information Act. But again, like you said, you have to jump through the hoops You got to do it in an effective way. Whatever, there's a lot of criticism about the new Malaysia, but I'm an absolute supporter of the new Malaysia. There's a lot of lessons for us to learn, surely, in the first year of administration. But also, I think this is the way we should be doing things. We should be thinking through things and not just having, a quick solution to a very, very complex problem. And especially now when Malaysians totally cherish their freedoms, the right to speak, the right to express, the right to assemble. Just take, for example, when Parliament is in session down the road. If you watch the news when Parliament is in session, there are always people picketing outside there. So you see, the right to assemble and the right to protest is a subset of the right to expression. And it is such an important right. I am very, very thankful and grateful that the new government is taking its time to really legislate on this, because anything else which is devoid of, intense debate and scrutiny is going to be it's not going to be popular with the masses, basically. Yeah. Yes?
Just now you said you were sympathetic with the Singaporean
legislation. Yeah. Okay, in a sense, I'm sympathetic at many levels, and I'll tell you why. Because I spent hours and hours observing the select committee hearings. The select committee hearings were broadcasted. They were subject to people just turning on to see it online on the web. There was an invitation from people who would be affected by any sort of this legislation. So it was a very modern, very democratic approach to making law, making policies and laws. I'm also very a supporter of the legislation. I wasn't when it first came out, but as I scrutinized it, I realized that it is a very sophisticated piece of legislation, and I wouldn't have expected anything lesser from Singapore. They had that for me. I think the biggest convincing aspect of the legislation was the guidelines within the sections itself to say that there is a threshold. For me, that was very important. Having researched this for a number of years, that is what I was looking for. So once we can see that there is a threshold, it's not an umbrella provision, that there are standards to be met. And they do talk about public interest in the Singapore legislation as well.
How do you think, if we make the legislation better, do you think it will help mitigate false news, or will it just be a legislation there to be there when we need it?
Okay, I think we have to go back to why we have laws. So if you look at the Singaporean Act, which came in, I think May, I can't remember now, there's not, to my knowledge, not a single prosecution so far. And I think that is the role of the law. I think the role of the law is a tool of education, it is a tool of awareness, it is deterring, it acts as a deterrent, and I think that is the most important thing. But having said that, it will be interesting to see again if there is a prosecution. So I hope that there is a prosecution. I don't wish that, but it will be interesting for us lawyers. Otherwise, it would just be an academic discussion, isn't it? It's only when you have a prosecution, then we will see to what extent the boundaries of the law is stretched, to what extent the defendant in Singapore be willing to challenge the legality of the law. So if something like this was in Malaysia, that would, people like Liberty for Lawyers would take up the case for free and take it on appeal and challenge, its constitutionality, which were the various attempts made when the Anti-Fake News Act was passed, because they said this act will have a chilling effect. So it would be very interesting if we did have a law like this, and to see how the legal fraternity, the civil rights activists, would respond to such a law. And in the case of Singapore, we'll wait for the first prosecution, and then we will have another discussion over a cup of tea and biscuits. Yes?
I'm just curious, Jasper, what exactly went on in before the act was, while they debated on the act?
It was simply, it didn't, there was a lot of engagement from the opposition. During the second reading debate, there was a lot of engagement, and in fact, it's a very good question, Wilma, because I have knowledge of the fact, and it's public knowledge, that at least the government or the minister in charge of the bill at that time did consider two things. One was, under Section 4 of the Act, they changed the word knowingly to maliciously, so they increased the standard a little higher. So Section 4 from knowingly to maliciously, meaning just because you know that it is false doesn't would have criminalized you. But now knowing alone is not sufficient, it has to be malicious. That's the first thing that, this is a bit progressive, that's what happened, because it's one of the concerns that was raised in the second reading debate. And the second thing was the punishment. So the penalty, for example, for Section 4 was, I think, 10 years, and then it was reduced to 6. I don't know why, these are magic numbers, but it'd be interesting to know why from 10 to 6, but it was reduced. The fines are in 6 figures, 100,000, 500,000, and Singapore is about 60,000, 50,000 Sing as well. So that is something that happened during the second reading debate. So when they went through the committee stage very quickly, these two amendments were considered. So there was some, like, again I use the word sophistication, but yeah, I mean, the government had the majority, they were able to push the bill through. So, yes.
You spoke about why it wasn't good. You criticized it. But out of the 14 sections, is there anything that, in your opinion, and I say it was, but it hasn't died yet, but is there anything that you think is good? Anything that we can build on, we can keep there?
There is, and if I could just take you back to some of the provisions. Okay, so take for instance this one here. If, for example, I put in let's say there's a communication or an online statement that is wrong, that is false, that's misleading about my reputation and my position, I may write to the Malaysian Communications Multimedia Commission, and I can even go to court to get that statement removed. So it's all not doom and gloom. In fact, if you look at the provisions, they're quite sensible. But the point is, the breadth of the definition of news, fake news, the extent of the publication. So I'm in disagreement with the extensive nature of the legislation, that it should be online, it shouldn't really be broaching on traditional media. It's not meant to deal with news. This is not the problem in Malaysia. So you have to understand, in every country, the phenomenon is different. So in Malaysia, it may be statements that cause, to denigrate a person's reputation, racial and religious disharmony. In India, it could be inciting hatred and hate communication, like in the UK. But there's a lot of hate communication, online hate crimes that are being committed in the UK, but they've decided to take a softly approach because they feel that other legislation still has the potential to cover hate speech and this sort of online falsehoods as well. So there are some countries that are not diving into a legislative initiative. They're taking it slow. Australia is one such example. But so there are some good things that are from the Act, which we can easily extrapolate. But that is one of the reasons why it was stalled in the Senate. So if you read the Hansard, one of the things that was said at the Senate stage, and they rejected the repealment, is that they were hoping for more of an amendment because they were also sympathetic towards this phenomenon. But of course, the government of the day had already made the promise to the people. It was part of their manifesto. After elections became their mandate, they promised they had to follow through the promise. And I think they were obligated to throw the baby out with the bathwater in this case. Okay.
Do you foresee them coming up with?
Yeah, I do. I can't comment. I do think they will. Yeah.
She didn't finish her sentence. What
I finished your sentence for her.
Do you foresee them coming up with a replacement?
Replacement. I do.
Because a lot of these things are political in nature, so they get rid of it because it's something of political.
Absolutely.
So they create a new one, even though it may be the exact same thing or sort of an improvement on it. But it's still based on the same thing, but it's theirs. So that's why.
Yeah. So one of the things that they can't use is that same phrase because it is synonymous to the previous regime. I mean, that's the way, it's whether you support a law or not is very much symptomatic to who is introducing it. So it leaves people with a bad taste in their mouth. But I think it's the way you do it. You have to rethink it. So this government has to be a bit more intelligent in the way in which they're doing this. But as lawyers and as law academics and scholars, we will still take our little yardstick and start measuring these provisions against the Constitution, against whether it's fair, this principle of fairness, equality. We will go back to that. So whether they come up with a new law or not, it will still be subject to scrutiny, and we should continue to do that, to carry out that kind of scrutiny. We should not stop. Otherwise, Article 10 would be frivolous.
I'm not so clear about why in that last slide you showed, you think the mainstream media should be excluded from if we do.
Yeah. Okay.
And I ask this because why should, in the first place, what is the mainstream media? Is the boundary very clear? And if it was clear, isn't it evolving as we speak, right? Isn't whatever the mainstream media used to be, now it's not so clear. There are organizations which straddle the border. And if it's the medium that you say that because it should be online, and not extend to printed media, but don't the mainstream media engage also in online publication?
Okay.
Then also that raises the issue of, are you implying that there are other laws, other legislation that should take care of, that maybe, because it's not a new, whatever is the law is trying to legislate against is not new. People have fitna since, long ago, libel, slander. But what's new now is the medium, and the rapidity and the scale at which.
The scale, absolutely, yeah.
So this is my thoughts.
Okay, you've answered your own question actually. Because Edmund was saying, why is it that I'm not keen to extending the legislation to mainstream media or to alternative media? Well, in Malaysia, alternative media is no longer alternative. So I feel, in terms of, that's since my area of specialization is media law, that is really a lecture for another day, because I do feel that we cannot talk about online falsehoods and communication, which anyone could be disseminating, versus when it is done by the media, because the media has to be accountable to a different metrics or measurement. They should be accountable to, say, a press council. They should be accountable to a code of conduct or practice, a code of ethics, which is an evolving area in Malaysia. As you know, they have set up the various committee to consider the evolution of maybe the responsibility of public service broadcasters to be more neutral in their reporting, to be more responsible, accountable. We have to come up with that. We have to separate the media. My view is because they play a different function and role.
But isn't that an ideal, not necessarily the reality?
Yeah.
Like I said, there are quasi
Yeah.
media, and which do not.
That's right. Yeah.
Subject themselves to regulation and accountability.
Yes. That would be an argument for the lawyers. It would be a interpretation argument whether the ambit and scope of the legislation would cover someone who is in this, rather what we call amphibious position, one who seems to be a normal person but is blogging like a journalist. Yeah, so we do have those problems where someone is quite amphibious. He can be an individual but functioning like a journalist. I think those problems will come up, Edmund. And that's where I think we need to have enough cases to argue when that situation comes up. And you have highlighted, firstly, that why am I delineating media from other communicators? The answer to that is because of the role and function of the media as the fourth estate, the role to inform the public, the role to disseminate information, the role to engage in national conversations. So, you know, I'm not promoting, but there is an article which I've written where I talk extensively about the role of media as the fourth estate, and we should regulate it separately from, let's say, you know, Joe Blog, who is talking about something that is, you know, false or fake, malinformed, misinformed. So I think there needs to be a delineation. And if there is a situation where there is someone who is amphibious and seem to be functioning analogously to that of a journalist, then I think that is a place for a great argument in court.
So where would offline falsehoods lie?
I think that will come under under other laws. I think you have the Printing Presses and Publications Act, you have the Sedition Act, you've got a whole host of, you know, legislation where you can cover that. So this must be unique to the nature of the phenomenon, that we are using messaging services, we are using social media platforms, we are using network computers because of the way they are pervasive. So there's this, yeah. I hope I've answered your question.
If you say that the government is intent on remedying the situation or coming up with a new solution to this problem, have you heard of any initiatives that they have already begun taking in
I think they're setting up task force at the moment. Yeah, they're setting up task force to look into it. Yeah. Because I think, you know, in Malaysia, like I said, in terms of even media rights, it is a vacuum. It's an unfilled legal basin of rights, because the only experience we've had with media rights, for example, is how to restrict media. So I think they're very busy with that. I think once they've settled, or maybe simultaneously consider this, because this is not going to go away, Vilma.
Yeah.
It's not going to go away.
It's something that's really
Yeah. So that's one, the rights of the media, and also the role of public service broadcasters. So as you know, people like RTM have come into, you know, the forefront of, conversations and debates about what is the real role of public service broadcasters. How do we stand our public service broadcaster to a standard? So for example, standard of neutrality, objectivity, because they're basically funded by taxpayers and not political parties. So, I mean, we are having those kind of conversations. Then we have the internet, then we have the big other, and all these big tech giants that are doing quite a lot of nonsense. You know, I mean, again, I've used the word Cambridge Analytica a number of times, things like that, where you're using bots, you're using people's data, manipulate news feeds. This is really ominous, because you know why? You really don't know who's behind it. So as you know, there's been a lot of answerability to the US Congress and the various committees in Congress about, you know, the last elections, and it's pretty much linked to online falsehoods, malinformation, disinformation. So the problem is quite complex. So it will take some time. And then, of course, we have to talk about election laws then. So for example, if you look at the Singapore guidelines, communication is likely to impact elections is one of the considerations that's in the legislation, yeah. So they are very concerned.
The Malaysian context, I recall, there was this problem of defining
Yeah.
And apparently it was the authority that will determine whether a piece of news is
Yeah.
authentic or fake.
Yes.
And of course, we know that when government suffer from credibility,
Yes.
then the general public will have lack of confidence
Yes.
on that piece of legislation.
Mm.
So what about the Singapore context? Because here it says that false statement of fact compared to our fake news, which is probably became popular because of President Trump.
Yes.
Yeah, but the Singaporean definition here, false statement of fact, how would you think they would explain that or define that?
Yeah. So one of the things that is unique to Singapore's legislation is that they have attempted to define, for example, what is statement of fact. They have attempted to define what is communication. So when we are looking at the legislation, so when in defining the communication of a false statement of fact, so what the prosecutors will have to do is look at all of these elements and ensure that they tick each box. And not only that, they have to ensure that they have the sufficient evidence to show that it was the maker of the statement who was communicating. So in a sense, before they can prosecute, they have to ensure all of these elements are satisfied. So going back to drafting a law, the more detailed you are in your interpretation section as to what each of these means. So what is meaning by material, what is meant by communication, what is meant by a statement of fact, what is meant by a false statement of fact. So that is what the prosecutor will rely on as elements of a crime, and he or she will have to ensure that there is evidence to prosecute. So in that sense, the more detailed the legislation is, the better quality the draftsmanship is, the more clear the law is, what do we get? We get clear parameters of the law. So going back to the title of my presentation, the legal parameters to be considered is that sort of clarity in drafting. So if we have that clarity in drafting, then it will be easy for the prosecutor to ensure those boxes are ticked. So you get what we call the evidence that you need that satisfies each element. Then of course, the question then is measuring that all up to the set of elements that the draftsman has put as likely to cause, that means the consequences. So once there is a clear statement that is false and misleading, the second stage now is for them to measure up to the consequences of that statement. So is it likely to bring in social disharmony, disrepute to a person, to incite public disorder, to incite disengagement with a foreign power, with another country. So that's the strength of the legislation. So one is looking at the offense, and secondly looking at the consequences. So if we don't have this sort of layering in the law, this sort of detail, this sort of clarity, then we are leaving too much to the prosecutor to decide. And I think this is the problem with a lot of the way in which the Multimedia Commission has been acting in the past. So for example, under the Anti-Fake News Act, they would be the prosecutors. So what it would have done is enhanced their role as the internet policeman. Then I've got some points I've stated. For example, who are they going to prosecute? So in the legislation, the maker of the statement, the disseminator of the statement, debates about should a WhatsApp administrator be accountable? Yes, if you assisted in disseminating, but just because you created the chat group does not make you guilty. You see, so that degree of criminality must be clear. So again, having an extensive legislation, because there was a joke, Mr. Loh, when the Singaporean legislation came out, oh, typical, they're going to control free speech. And this is really, I think, foolish, very, very naive. When you haven't even looked, oh, so typical of Singapore, come out with 62 sections, you know, that sort of really unnecessary ridicule when you haven't even investigated the law. But it's the way they've done it, and they've done it with great class, and they've done it with great clarity. You can say whatever you want, that it is going to impede free speech. It's been months. So if you think that they were going to be very trigger happy with this legislation, to my knowledge, there's not been a prosecution. And that has not quietened down conversation on social media in Singapore, because you're dealing with a whole generation of young electorates that are very, very vocal. That hasn't silenced, just like in Malaysia, which is again a lecture for another day. How effective are these laws? Maybe they serve, like I said, to educate, to create awareness, to deter. So they're doing a very good job, I must say. Yeah.
But one thing I noticed when the anti-fake law in Malaysia came out, it makes us more careful and more aware of fake news. You know? Before that, we seem to accept at face value whatever information
absolutely.
we get
Yeah.
through the social media. But after that, we start querying and start looking critically at it. And of course, we don't like the fact that the fake news was not really well defined.
Yeah.
But the thing is, we have to be very careful also not to be instigated or to be part of the scheme. Maybe with the intention to cause harm.
So this is what I was saying, Mr. Loh, the chilling effect. So it did have a certain impact on silencing us, but more to be careful, more to be cautious. So for example, I don't know how many of you have looked at Sebenarnya. Sebenarnya is a fact-checking website, and I think that's a very effective way. Actually, it's very simple to know whether something, so if you really want to know whether Tom Jones has passed away, just Google it and you realize no media outlet has covered it. He's, like I say, probably performing a concert to some very excitable ladies. And that's you see, this is where we also need to consider the behavioral impact, the deterrent impact of legislation. But I think we hated the Fake News Act. Hate is a very strong word, but I think it is correctly used here. I think we hated the act because it was just the timing. It looked desperate. It made us the ridicule of the world. Here we go again, another regulated nation pretending to be a democracy. It questioned our integrity as a people. It questioned the integrity of our parliamentarians. So that is why this government has to be cautious, because this is really a different environment we are living in today. And because it is so hard fought, what happened on May 9th is so hard fought, that whatever this government do or does will be subject to a lot of ridicule. It is being subject to a lot of scrutiny. It will be subject to using my word, a very high threshold. So I suppose that wait and see, acting with caution before they come out with the law is really the way to go. Because if there is some kind of communication that has harmful consequences, if you ask me, there's enough traditional laws that you can stretch far enough without breaking to prosecute that sort of harm.
Thank you for sharing your views.
Most welcome.
One more question, Dr.
Okay, Mr. Mark.
Do you think that with the amount of laws that we have, including the multimedia and communication laws, do you think that we still need a fake news act? Because with the existing laws, it should be enough to catch anyone and everyone.
Yeah. There is a discussion then. Then what would you say about countries that have legislated? I think if you look at the sections within the Communications and Multimedia Act, they are wide enough to cover, for example, to annoy, harass, threaten, abuse. But it doesn't cover the nature of falsity. You know, when you say annoy, threaten, harass, abuse, it doesn't cover online communication that may cause disrepute or, you know, vigilantism, some kind of a harmful consequences. But there is a school of thought here in Malaysia, and as recent as a week or two ago, there was an article in the newspaper. For example, Ambiga wrote an article with Ding Joanne, and they felt that we didn't need a new legislation because they felt that it is wide enough to cover. But I'll tell you what is the danger. The danger is in the interpretation, Mark. Whether our courts are willing enough to stretch the traditional law to cover a non-traditional phenomenon. That's the worry. So in a world where, you know, we're using technology as a transformative tool, why can't we use law as a transformative tool? Why can't law be equally scientific and precise? Why leave so much of doubt to the courts? Why leave so much of doubt to the lawyers? It's only going to be as good as the lawyers who are defending the case. What if that particular lawyer is unable to look at the parameters of the law? What he is unable to say that, oh, you stretch the law to a point where it's breaking. So it's best to have a lex specialist.
I want to ask two questions. First question, you say that public interest is not defined. Now, public is so fundamental in criminal law and constitutional law. The country is independent from 1947 today. And I have my reservation whether it's not defined or not. Because in criminal law, a law must be very, very precise. So, because you are taking public for a criminal prosecution, so there will be very clear definition of what is public interest. Okay. Now, if you look at civil servant can be dismissed from service for public interest reasons. Now, my blind kind of thinking, there must be a definition of public interest somewhere. If it's absent in the legislation, then it must be present in the just-made law. That means when the case went to court, I'm very sure some case will have gone to the court, and from your understanding, from the reading of case law, is there anywhere what is public interest is defined? Question number one. Question number two, main legislation, subsidiary legislation. The main legislation is the one, the Parent Act. When the Parent Act is passed in the Parliament, the subsidiary legislation should support the parental, whatever the Parent Act. So that means, if for any law, there must be subsidiary legislation.
Regulations, yeah.
To support it and enforce the law. In the event there is no subsidiary legislation, in Malaysia, if the penal code can provide that subsidiary legislation to enforce this law. The reason why there is a question, the guideline you're talking about just now, could that be part of the subsidiary legislation which should be come with the package together? So at the moment, what I'm to ask you, the first one, is that there any definition of public interest in anywhere in Malaysian legal history? Question number one. Question number two, although there is no guideline for this, the existing law, will it take care of to implement the law?
Okay, so going back to your first question, I can tell you quite easily that if you are looking for a definition of public interest, I found it in other schools of thought. I found it in other areas, not law, in other disciplines. For example, media. In media studies, there is consideration of what is public interest. Public interest means what is of interest to the public and not interesting to the public, for example. So there's a lot of media theories who've written about public interest. In the courts will look at situations that could be in the public interest. So for example, doing something, for example, whistleblowing could be seen as an act that is in the public interest, that serves the public interest. I have looked at even English jurisprudence, and there is, I think the courts are cautious not to define it, because the problem is once you define it, it will be exhaustive, it will be seen as restrictive. So what they're looking at is situations that could be in favor of public interest. This is my experience from the reading of the judgments.
But very interesting, because in the law is not defined, there's a gap in the law.
Yeah.
The judge make the law to fill the gap.
Correct. So the judges,
make the law.
Yeah.
Because doctrine of status is, it becomes a law.
yes, I'm aware of that. But this is where the courts are not doing that. The court do not want to define public interest. They're looking at, for example, if you look at certain criminal legislation, my colleague has left, who's a criminal lawyer, she would tell you that there are certain words in the legislation, for example, in the UK Theft Act, to dishonestly appropriate property, the term dishonesty may not be defined, but but the court may look at situations where something could be amount to maybe the opposite of dishonesty. So the court has in the past set precedent in the way of explaining what could amount to in favor of public interest, for example, or in disfavor, but it has not defined public interest. And I think it's rightfully the case, because law academics and scholars to say, one of the problems that we have with definition is it becomes exhaustive, it becomes restrictive. In respect to the second question, when we are interpreting anything within a law, we can find inspiration from other legislation. So yes, maybe to a certain extent, we can extrapolate between legislation to sort of explain away what something means. But again, that is going a bit to, it depends on how good your lawyer is, how good the prosecutor is. So again, like you said, you're filling in the lacuna, you're filling in the gaps. So if you have clear and precise draftsmanship, that would not leave much to uncertainty, and it would not leave much to ambiguity. And I think we need a certain standard of legal precision. And sometimes, whilst I'm in favor of the common law system, but I think we have come across occasions where the judges have disappointed us and just being very polite. So I think it's Parliament's responsibility to ensure, and especially in a functioning and legitimate democracy, I think Parliament must be the starting point in taking responsibility. If it's a phenomenon that is causing people dilemma and it's causing people harm, then that should really be within the purview of Parliament and the responsibility of Parliament.
That thing didn't occur because of lack of judicial activism in Malaysia.
What?
The definition of
No.
Not because
no.
Just say there's a brave lawyer who come and say that, all right, in my interpretation of this particular case, this is public interest. This is my definition, judicial activism. And what I feel in the Malaysian context, because the racial combination of issues and many other things, maybe the judges are not brave enough to become more judicial activists.
I don't think it's unique to Malaysia. I think, I've done comparative study with us and the English common law system. It is the same there. It's as if the judges shy away from a definition.
But what about in India?
No, I haven't explored. Yeah. Because the way they look at public interest could, they have things like public interest litigation. So it's something worth exploring. Yeah. Yeah. But to my, limited boundaries of knowledge, it has not been defined. But yes, I think it's a good suggestion. I will have a look. Yeah. Thank you very much. If there are no questions, I'll pass it on to Dr. Edmund.
Okay, once again, thank you for coming. Thank you, Dr. Jaspar.
Thank you very much. Thank you.
Look forward to more participation at our future seminars. I think it's going to be held almost every Wednesday between 12 to 2 at different locations, but look out for those emails. We need to, I noticed maybe it's not being sent to all students, the communication is being sent to all the faculty.
I think it's good to spread it out.
Yeah, the faculties normally announce it to their students as we did. Yeah, yeah.